have been introduced already, and I will just be addressing the issues of digital rights perspective, in particular with data protection and why it's important, right? So maybe I should start with an explanation of what are digital rights, right? So the digital rights are cyber rights that recognize the rights of the individuals to access, to use, to create and publish digital media, and the right of access to the computers, electronic devices, and the telecommunications network necessary to exercise them, right? And these rights are used merely as an extension of the rights set out to you in the Universal Declaration of Human Rights by the United Nations. And this should be applied in the online world. But the rights that you already have, the rights that are already accorded to you by Constitution, it's just, this term is just referred to using those same rights and sort of accord them within an online world, right? The main objectives of looking at digital rights are to guarantee access to the internet, but also avoiding the so-called digital divide, and a proper use of networks such as the common set of belonging to the whole of humanity. So how are digital rights exercised, right? You exercise as humans, me and you, we exercise these digital rights through chatting online, sharing content on social media, shopping online, using connected objects, and reading the news and making payments and on smartphones, just amongst others. So all digital interactions really that represent new possibilities for exercising individual and collective rights in the digital age. So what are some of the considerations on why digital rights, in particular on data protection, right? So while acknowledging and understanding the disruptive effects of digital technologies, it is critical in ensuring that continued protection of the rights upon which our societies are built. Citizens are increasingly wondering if and how governments can protect their rights in the digital age, and whether existing policies and legal safeguards are fit for purpose. And I think this is where our government and many other governments in the region, but also throughout the world, has decided to come up with the data protection as a bill, as a means of protecting rights online. All right? So in that, a lot of people are asking, or citizens around the world are asking, what does privacy, for instance, mean in an era where real-time data is collected, real-time data collection is the norm, with potential risk of data breaches, identity theft, and online fraud. But also other questions are, can we really fully enjoy our freedoms of expressions across digital tools and platforms without fear, censoring, and profiling? This is very key, particularly for human rights defenders, for journalists, for politicians, just amongst others, right? But also, another key question has been, can everyone have equal access to safe and trustworthy information when harmful content and untruths are widely disseminated online? Others are also asking, how can we make sure that new technologies contribute to bridging the digital divide instead of worsening existing inequalities? So why protections, right? So as technologies keep evolving at a very fast rate, it is fundamental to reassess and adopt our conceptual and regulatory frameworks in order to maintain rights in the digital age, but also to ensure effective enforcement and redress of mechanisms. This is what the OECD proposes. All right. So amongst others, these are some of the global efforts that Some of the countries have opted for broad policy framework around digital rights, such as digital transformation across levels of government. We are experiencing that in Namibia, where we are able to access different digital services online. I think you'll be able to file your text online using, I think, through NAMRA, for instance. One of the other key government services pertaining to digital transformation has been the student funds through NASFAP, just amongst others. But also others have been beginning, or other countries also began to explore the development of new digital rights in specific domains. For instance, mapping selected gaps where there is a need for algorithmic transparency and accountability for decisions made by artificial intelligence. While other countries have prioritized protecting rights online in the same way that they are protecting offline. This calls for constitutional recognitions that the rights that are provided to you or are guaranteed to you should also be recognized online. All right? So what are some of the key considerations that we think the Namibia Data Protection Bill should consider regarding digital rights in particular? So number one, we've been asking, or we think that, for instance, the current bill need to recognize and dedicate a sort of section or provisions that recognizes the rights of users. But the bill should include a standalone clause that recognizes the rights of data subjects, the right to transparency, rights to access, right to be informed, and rights to rectification, rights to restricting processing, data portability, the right to object, very important, right not to be subject to automated individual decision-making, and including profiling amongst others. I just saw when Mr. Muhapi was presenting the sort of sections of the bill, and the copy that I have are totally different. So previously there has been some sort of mentioning in part 4, in section 43, where there's exceptions that makes mentions of the rights, but the rights need to be stipulated because this is a people's bill, right? And it should focus on people, right? But also the right to be forgotten. I'll be happy to, I'll share with you, I think in my next slide, just a small case study on the right to be forgotten in Namibia. So we believe that the bill should have a clause that provides for the right to oblivion, that is the right to delete information and records of the past in the cyberspace, and clearly spell out the data retention period. But also specific consideration regarding whistleblowing, right? As a right. Bill should have a clause that guarantees the protection of whistleblower in terms of handling investigation, right? That also goes to work with the revision of the Whistleblower Protection Act, number 10 of 2017. So why the right to be forgotten? I think I've just mentioned this. Does anybody know these people? Yes, all right. The lady here knows somebody. Can we get an engagement? Director of somebody? Yeah. You want to get a mic, right? Could you just tell us about them?
Who did you recognize in the picture? That's the question. You didn't marry, what is it?
Please raise your hand if you know anything about what you see on.
Who want to give it a try?
I think the lady here has said something. Please, I'm not putting you on the spot. Just say something, right?
I remember the young gentleman in the blue. There was a video online going viral about him. I kind of just forgot about what, but yeah, he stays in the north, that side of Jimelo, if I'm not mistaken.
Then you have
Thank you. Yes. So that's a bit of context on the photo on the, is that far right or left? All right, far right. Right, this gentleman is a young, vulnerable boy who has been coming online without obviously his consent, right? A lot of us see many of these vulnerable Namibians. We take photos of them because they're saying something funny and we post them online for likes and for anything else, right? Most of the time we buy them alcohol so that they can be as entertaining as possible for our likes on social media, just amongst others, right? That's their data. That's the gentleman's data. This boy, I want to believe, used to be under 18. And this was a Google search. This school search should have increased by today about this young man. He has not consented for his data, for his information to be online, right? So he cannot even ask, perhaps when he becomes as literate as possible, to get all of that information to be taken off, right? He has a right to be forgotten. He has a right not to be onto the internet, right? Because he has not consented to be on the internet. Right here is Auntie Vivi. I'm sure many of us has also gotten to know Auntie Vivi. So the lady that died, I think, over 9 years ago in Namibia was covered obviously by mainstream media, but also covered by a lot of us under the same context as Irimari over there. She has died. Her information is still onto the internet. I think if you just do a Google search or Facebook search, you still find all of her videos being vulgar and entertaining people for a small beer or whatever that we pay these people to get online. This lady and her family has the right to be forgotten and not to be onto the internet, right? And whether she stays onto the internet, that decision should be made by her family, maybe want to preserve her memories or whatever. But she has never had a Facebook account or Google account or put on information online, right? So the right to be forgotten, and the reason why we are asking that the bill, for instance, should recognize that as a digital right, right? And then obviously there's also some key gender considerations, right? We have asked previously that the bill should prioritize a specific section in the protection of women online, in accordance with CEDAW, but also Article 18 of the African Commission on Human and People's Rights. That there was a need to include provisions of criminalization of online violence against women and girls, and this should to Section 14 of the should work with Section 14 of the data of the draft cybercrime bill of 2019. I'm not too sure what the versions of the current version of the bill that we have. What we have also asked is that as part of the digital rights, that there's a need to introduce nuances to the rectification process that includes specific provisions for victims, particularly of online violence. Currently, the process of rectifying harms, as was outlined in Section 9, lacks specific measure for restitution that can be taken by victims in the case of non-consensual image sharing or revenge pornography, and generally in the commercial loss of data. All right. There was also a need to expand Section 53. I think this is the version that I had of yesterday, regarding trans-border flow of personal data. This will have to do with addressing obligations to victims in the case of transfer of data by perpetrators, and this should also align with the Section 13, 15, 17 of the Cybercrime Bill of 2019. Other general considerations were just that there's a need to include time under which the security breach of users should be users should be notified that there's a need to strike a balance between the protection of national security and the exercises of rights of ordinary individuals, and finally to specify on sensitive data. I know that there's a number of obligations. That was in part 3 of the versions that I had yesterday, that deals with the health information, religious belief, and political opinions, but can be very sort of nuanced for specific purposes. All right, and this is my last slide. It's just that the bill should not be standing alone and should be aligned with a number of many of our standing regulations, policies, and Act of Parliament, and particularly should be aligned with the draft cybercrime bill to acknowledge child-related data for processing alongside child sexual abuse materials and those related to cyber grooming. Thank you, everyone, and I end here today. I'm happy to.
It was very insightful. It speaks about your right when you're online. You have the right to be forgotten. And when I heard that, I want also to apply, right?
But let me try and attempt and answer this to my best of ability. There was a question related to the consent of your materials, for instance, when you die or when you pass on, right? And that I think was a bit more aligned to the right to be forgotten that I have flighted, right? So happy, do we have the right to be forgotten now? In the final view.
I think we had serious discussions, over all these aspects, and I think you'll see under section 74, 75, dealing with the regulations, that some of these principles can only be detailed in the regulations, so that you leave the legal framework. You don't want to be too broad, right? Those will be really contained, in the regulations. Because I think currently they are in the GDPR, which is more regulations, right? Yeah, so I think that's how we want to deal with those aspects as well. Thank you.
Okay. So I hope that answers to your question to a certain extent. That, for instance, the right to be forgotten, in this case, which would specify exactly what, for instance, the internet intermediaries, such as your Facebook and all these other platforms, should abide to. And that it should be left into the regulations. From my personal perspective, I've said that there's a need for us to focus that as particular provisions within the Act itself, and it should stipulate all the rights that I have as a user. That leaving it to regulations can be very losing to a lot of people as citizens that just needs the protection. They need to know, right? And then there was a question. So in relation to what you were just talking about, or what you have asked regarding dying and leaving the information, the right to be forgotten can also be exercised the same way. Say I'm on Facebook today and I deactivate, that all of the materials that I've put online should be taken off, right? What we know, for instance, right now is that if you deactivate your account, right, and you start to Google search yourself, those images will pop up again, even if you're not on the same social platforms. And that's the worry. And that's, I think, what we're asking that, for instance, the Act should make provisions, one, also that for internet intermediaries, which are the platforms, to abide to. Right? Then there was a question on the usage of platforms such as Truecallers. Now that's also related to other intermediaries of the internet. What we're seeing, for instance, maybe just an example that I can share. What we're seeing, for instance, in regards to sharing of somebody else's information to others. Well, we know I've worked a couple of times with companies, organizations in South Africa. And when the POPIA Act came into place, they refused, for instance, they had to abide immediately to making sure that I don't share information about the next person to someone else. Because I'm not too sure if there was a regulation or it was a clear provisions within the POPIA Act that has called for that. One, that will then obviously ask us as a country, obviously, for to ensure that internet intermediaries such as platforms that we use, applications that we use, they now abide to releasing all the information that was possibly put there by Namibians under their consent in the absence of the law.